Hello, I'm Quinton Newcomb,
And I'm Shiv Haria-Shah.
and we're partners in Field Fisher, specialising in compliance and investigations work.
As a firm, we have a large pan-European team of professionals advising clients across the full range of legal and regulatory compliance matters. Just one area of compliance that we assist with is in relation to economic crime prevention, and that's what we're here to focus on in this video today.
There have been some significant recent developments in this area in the UK, which are affecting UK and international businesses. In some, the risk exposure for businesses from economic crime has never been higher, and we're expecting a significant and sustained increase in criminal enforcement action against companies who do business in the UK over the coming years.
We're talking, of course, specifically today about the impact of the Economic Crime and Corporate Transparency Act 2023, otherwise known as ECCTA, which has introduced the most dramatic changes to corporate criminal liability in the UK for several decades.
On the 26th of December of 2023, the government lowered the bar for prosecuting companies for economic crime, be it fraud, bribery, sanctions evasion, money laundering, or a host of other economic crime offences, so that the criminal conduct of senior managers can result in criminal liability for companies. That is a significant lowering of the bar from the position which previously existed, where liability would only flow from the crime in question, where it was proven against a person at board level.
On the 1st of September this year, the risks for companies will increase further when a new failure to prevent fraud offence will come into force. The offence will give rise to liability where a person associated with a company commits a fraud offence for the benefit of that company. An associated person, of course, can include employees, subsidiaries, and many other third parties such as agents. And the offence is strict liability. In other words, where the offence is committed, the company will be guilty.
The one opportunity for a company to defend itself against the threat of a conviction is a single statutory defence, namely the defence of having in place reasonable fraud prevention procedures. Just as with the failure to prevent bribery and the failure to prevent a facilitation of tax evasion offences, which are already in force, the government has issued formal statutory guidance in order to assist companies in reaching the reasonable fraud prevention procedures bar. That guidance was published on the 6th of November of last year.
And since that date, we've been advising companies on what the changes brought about by ECCTA mean for them and how to transform that guidance into tangible changes to their compliance programs in order to mitigate their risk of exposure under the Act.
Drawing on this experience, in this series of short videos featuring different members of our specialist team, we'll be focusing upon one of the 6 principles set out in the guidance at a time, seeking to highlight key points relating to each.
We hope that you find the videos insightful, and if you'd like to discuss how these changes will affect your businesses, then please don't hesitate to contact us.